It please the court. My name is Christopher Palermo. I'm here on behalf of the appellants in this matter, and I ask if I can reserve 5 minutes of my 20 minutes for rebuttal.
You may.
Thank you. Just a brief overview on this particular appeal. This really comes down to a motion to dismiss and the four corners of the complaint. What we found in the lower court ruling where the error occurred is the lower court did not look fully at the continuing tort doctrine that was pled sufficiently.
Yeah, I'm
Yes.
curious about that, because I understand after your clients sold property, if you will, there are subsequent transactions.
Yes.
But the fact of the matter is, they lost their property once.
And this is the crux of the matter, Your Honor. The first transaction we believe, and what's pled and what we believe the facts will show ultimately, was done by fraud. There was never consent to the initial transaction. The title company that collaborated, who's actually the appellee here today, they knew that transaction was not consented to. They worked in conjunction with the original purchaser, the original fraudster who has a criminal record. It's in the record. And they went ahead and conducted the transaction. My clients immediately protested. They filed a police report.
Doesn't that strengthen the case that the statute started running at that time? They knew they lost their property.
But they were sued immediately. Okay, they were sued immediately and
For
ejectment.
And that's the one over in Orlando.
In Orlando, that's
Okay.
right. That's right. And they held on to their equitable rights. A constructive trust was established that day. And the reason the first foreclosure action was not successful was because Mr. Bates, who was the fraudster who was incarcerated, he could never get around their equitable claim because he could never say he was a purchaser without value, without knowledge. So he had to deal with the allegations of a rightful transaction. He had to deal with their claims of fraud. He never could defeat them. So what he came up with, and what we're going to ultimately prove, and what we pled, was he brought in a second party called Bandersea. And then he brought in a third party named Jeremiah. So what they were able to do was they were able to move the title twice and allow Jeremiah now to stand in the position of a purchaser for value without knowledge. So what happened was that second transaction in 17 strengthened the hold on the fraud team. The fraud team.
I don't mean to sound dense,
Okay.
but it's like in a malpractice case. Your injury occurred when they cut off the wrong leg. The fact that you may have subsequent conditions or things that flow from that, the fact is, when you cut off the wrong leg, that's when the cause arose.
And Your Honor,
Go ahead.
I know, I agree with you. I think this is the crux of the matter. This is exactly the crux of the
Because they're
matter.
not involved, your clients are not involved in either of the two subsequent transactions.
Well,
They're not title holders anymore.
they're constructive trust, equitable title holders. See, that is the key here. They have equitable.
I want to just clarify, is that an argument that you're making, or that was actually, there was a court proceeding and that was determined?
No, these are the facts.
Okay, well, I actually am somewhat confused about the facts, and let me clarify, and what you said confused me further. So this closing occurred and they filed a police report. And then you said they immediately, and I'm assuming what you mean is Bates filed an ejectment, or are you referring to years later
No, Bates filed an immediate ejectment action.
at the same time, about the same time of police?
Yes, because if you look at Exhibit A to the
And
second.
so has that ejectment, do we know from this record whether that ejectment action concluded?
They were never successful.
Can you use names, because I don't know who they.
Bates, I know, it's a lot of, okay, so
Bates was
we'll
not
talk about Bates, yes,
successful
let's,
in the is that in something that's in our record?
it's
I'm
in,
trying not to go
it is
outside the record.
detailed in the complaint, it's put in Exhibit A, it's in the record, it's part of the pleading.
Well, I read the complaint, and and this is really, I know but this is an aside, but it's got me curious, especially in connection with the tipsy coachman argument. I read the complaint, and I'm trying to understand if your clients were unaware of this, this fraud that occurred, like somebody signed for them, forged these documents, got with the title company, they did a closing. How is it that there's any relationship between your clients and the title company that would give rise to a fiduciary duty? Because they have no relationship. They were,
Interesting.
so
I think that's the second, you know what, these are the two big, huge issues.
I'm like, how?
So, you know, it's funny, because let's just say, even though there was a fraudulent intent in the initial relationship between the title company and the first fraudulent purchaser, they took on, even though they intended to commit fraud by taking on the mere mantle of the title closer, unbeknownst, they still owed a fiduciary duty to both. You just assume there's, okay, let me give you an analogy. I'll give you a hypothetical. Let's just say that I, as an attorney, take on a job, whatever the case may be. I'm a transaction attorney, and I work in cahoots with a construction company to get my client to sign with them to somehow bilk my client, and I'm getting a kickback, okay?
Oh, but you have
But
different
it's-
obligations as an attorney.
Yeah,
But it's still
And
a
it's a
fiduciary
client.
duty.
I mean,
When I'm a closing agent, I don't care if I've ever met the people. I don't care what the deal is. I have a fiduciary duty for both. Even though my full intention is to violate that fiduciary duty, even though I'm a fraudster, by stepping into the situation of a title closer, a title insurer, a transfer of title, a neutral broker for both, I have assumed a fiduciary duty. Even though my intention was fully to break it, I have assumed that duty. By just the mere circumstance of being in the
Well, if
transaction.
let's assume that's correct for the moment. When did this first transaction occur?
It was 2015, the first.
So they know they've been billed. They call the cops.
Yes.
The cops investigate. They're facing an ejectment action in Orlando,
Yes.
and they sit on their hands.
No, they did not. They hired,
Why did they sue them right away?
they did. They got sued and they filed a counteraction in Orange. And that went on.
they sued the title company?
No, they defended.
Well, I think, I thought maybe Judge LaRose was asking, why did they sue the title company?
No, they sued the fraudster. They were limited. And really, they did not get all the best legal counsel that they should have along the way, but they did not sit on their hands. They fought and fought. And Mr. Bates, the first purchaser in the chain, he got so frustrated that he's like, I've got to liquidate. So he put $7,000 on a house. Okay, he basically for $7,000 acquired this house. He then turned around.
Satisfied a tax, potential tax.
Exactly.
Okay.
So they took a house that was worth $80,000, $100,000, and he, in conjunction with the title company, pushed the transaction through at 7,000 and some change.
But let's assume that he knows the fraudster, he knows that your plans to know who the fraudsters are. Why wait so late to bring in the title company? They know at day one, the title company is involved in this so-called fraud.
So what ends up happening is the title company interjects themselves again in the second transaction. See, if the title company had walked away from that first transaction and said, man, we really messed up here. I'm washing my hands of this situation, because they knew. The record is clear, the complaint is clear that my clients called the title company initially and were told, don't do this again, we're kind of intimidated. When the second transaction occurred and they were served again with a new ejectment action with a new party, as we've unraveled this and taken back the layers of the onion, lo and behold, the same title company that knew of the fraudulent claim that was made on the first transaction, they went ahead and facilitated the second transaction.
Well, I guess I would say, so what? Because your clients apparently knew that they were involved in the first fraudulent transaction.
My clients did not realize that this second transaction was going on.
No, but they knew about the first one.
But that's the continuing tort doctrine. You see, this is where we're getting to. You're right. If that first transaction was isolated in and of itself, and that was the only harm, you're right. That second transaction weakened, kind of like mend the hold. It weakened their hold on their equitable title.
But it's continuing harm to the plaintiff. And I'm trying to pinpoint the continuing harm because in 2015, they lost that home. That set the cause right to pursue, and any subsequent transactions involve complete strangers to your clients.
Well, the case law on the continuing tort doctrine, there's a lot of case law that we cited to. I can go through it here in the brief, but let me summarize.
My basic point, right, is continuing harm to the initial plaintiff.
It's not, okay, and I think you're absolutely right. This is the crux. It's not continuing harm from the first transaction. It's taking the harm that occurred from the first transaction and exacerbating it, continuing it, accelerating it, and advancing it through their wrongful actions in the second transaction. So think of it this way. The minute I have a piece of property stolen from me, I immediately have if I say it was, and I don't give up possession, I have a constructive trust. I have an equitable claim on the property. And that claim is strong against certain people. The one person that claim gets defeated by is a purchaser for value without knowledge. So if I can take the owner, the title owner, not the equitable owner, but the title owner, and convert that person from a person who could never argue no knowledge, and then put it over to somebody who has a plausible claim of no knowledge, purchaser for value without knowledge. And in the meantime, the first guy liquidates a $7,000 transaction for a $70,000 payoff, then turns around, a middleman makes 15, and now the last person in the chain has a house for $85,000 that's worth 150.
Well, you may have a great claim against the fraudsters, but I'm having trouble. I'm struggling with the notion that from one transaction, the title company continues on the hook.
Well, let's just look at it purely from the title company's situation. If it was just merely that one transaction in 2015, absolutely correct. Over, done. It was them participating in the second transaction. I'll give you an analogy.
To me, that's more like you're already revived the claim.
It really, in a strange sense, it stands alone as harm.
I'm really having trouble seeing the continuing aspect of it.
It has to be viewed, Your Honor, it has to be viewed through the prism of constructive trust, property rights, and purchasers for value without knowledge.
And
If
so,
we sit on that
and
prism,
so, if I'm understanding, your argument essentially is the second transaction that the title company was involved in actually impaired the rights, these constructive rights, the equitable interest, et cetera, et cetera. So it's just further damage to their title, however that title is gonna be designated,
yes,
further damaging it.
yes.
Okay.
But for their behavior, but for how they completely violated every professional standard in 2017, but for that second transaction, my clients would have never had to face a new opponent with a stronger claim in equity. Because what happened was the first
Sir,
fraudster.
you're at 15 minutes and I'm not
Okay.
cutting you off. I just want you to know.
No, I think we've hit a lot. Let me reserve 5 minutes for rebuttal, okay?
Okay,
Thank
all
you.
right, thank you.
Good morning and may it please the court. I'm Christian Waugh on behalf of Appalachia's Roseanne Carter and Riverview Title. I do want to say at the onset what we're going to ask this court to do is to affirm what we think is a great order. There are 3 arguments that are actually made in the initial brief, but I want to address 2 points that just came up in the oral argument first. The first is this idea that a fiduciary duty can be created simply by the title company undertaking a transaction. There's a ton of case law on this. I'm going to just cite Doe versus Evans, a Florida Supreme Court case from 2002. Don't have the number cite, but what they talk about at the Supreme Court is that a fiduciary relationship can only be created when, number one, someone reposes their trust in another party, which is the element that's missing here, and the other side accepts the trust. I think on the record and under the allegations of the complaint, certainly my clients accepted, the duties of a transaction. But if the allegations of the second amended complaint are to be believed, then they never reposed their trust in my clients. The second point that came up in an oral argument that I want to address quickly is the nature of the continuing tort doctrine, Your Honors. There's a specific formulation in the case law that's cited in our briefs, and what it talks about is it's not a continuing harm. Multiple harms, different kinds of harms that come from an act does not constitute a continuing tort. What constitutes a continuing tort is continuous wrongs. So in the Goodwin v. Spat case, 114 Southern 3rd, 1092 from this court in 2013, what this court found is that when there's, under the facts, continuous misrepresentations from a party perpetuating a fraud, it's not just one party intending the other to rely on one statement, it's several statements, and then that can give rise to the continuing tort doctrine. Here, and I think this is what the trial court struggled with, I certainly struggled with it. There's a 2015 transaction where my clients were the closing agents, admittedly. We accept the facts of the complaint for the purposes of a motion to dismiss, and that closed January 2015. You've heard both an oral argument and I think read in the briefs that they were on notice. They initially started taking actions. None of them were against the title company. But once title was divested from them, all these other things started happening. That started the clock. And for statute of limitations purposes, when it comes to a breach of fiduciary duty action, the action accrues when the damages first occur. And all the damages don't have to have occurred. The implications of appellant's argument to this court this morning, I think they occurred to me as I was sitting. If this court was to find that a later on transaction could somehow revive an action that was extinguished, or in the title context, which is the specific facts we're dealing with, someone 6 years down the line sells the property, goes to the same title company. Does that get a jilted seller back in the door for a breach of fiduciary duty action? Is it 10 years down the line? Do we have to wait for the Marketable Record Title Act to extinguish it 30-plus
But
years.
if we take the complaint as it is, it's odd that we continue to use the same title company. And that suggests that the title company may very well be part of this plot. It's not like they went to ABC Title Company for the second and third transaction.
Yes, Your Honor.
Why does that not make a difference?
Well, first of all, again, I concede we have to accept the allegations and the complaint. I don't think it makes a difference because it's beyond the statute of limitations. Even if we are to accept, I think, what appellants are saying about the second transaction, where they went back to Riverview Title. Under the terms of their complaint, that transaction closed May 23rd, 2017. This complaint was filed June 3rd, 2021. They missed it by 10 days. And that was the state of the pleadings for the original complaint and the first amended complaint. And that's why the court dismissed those complaints, because even under the second transaction, it didn't fit the 4 years. So in the second amended complaint, what we see is they added this allegation that the services didn't stop May 23rd. What they ended up saying in the second amendment complaint is, even though it closed May 23rd, the title clearly transferred May 23rd. All they say in the complaint is the services continued into mid-June 2021. And then in the brief, Your Honor, they actually put stuff that's not in the complaint. And what they tell this court is useful for us in thinking about this. Because what they said in the brief is that these are the services that were done: recording, escrow services, title examination. They refer to page 1359 of the record. It's not in there, but my point is, what effect would recording, escrow, or title examination have on an action accruing?
Right, your friend on the other side tells us it's to take care of the furtherance of this conspiracy. I mean, doesn't that count for something?
I don't think so, Your Honor, because it's the title transaction that is leading to ultimately the ejectment that they're claiming. Whether a document's recorded is irrelevant. It has nothing to do with anything. Once the deed is signed, that's when a conveyance occurs. It doesn't have to be recorded. So what does a title examination have to do? I mean, none of these things have to do with a cause of action accruing. But if we take them at face value, and even though they're not a party to the transaction in 2017, but even so, it's the conveyance itself that they're latching onto, and it's just too late to make it.
Remind me, if we could step aside for a moment, remind me, not going outside the record, what, if anything, is still pending in Orlando?
Your Honor, my party is not
You're not in that.
we're not in it, so I don't know. Learned co-counsel may be able to speak to that. I don't know if the court will want to hear from it now or after.
Yeah.
Yeah.
Your Honor, it's Maya Hatcher on behalf of Jaramillo LLC and Jaramillo individually. The Orlando action is still going. It is set for trial at this point, and we're proceeding to trial.
Thank you. That's without your comment.
Correct. So far, Your Honor.
Okay.
Can I say one thing for the record? We attempted to amend them into Orange County years ago, they wouldn't let
I
us.
think,
They wouldn't.
yeah, I apologize. So getting back to what we really feel strongly about the fact that a title company, and I think these are unique facts. I actually think that the fact that this is a breach of fiduciary duty action, as opposed to a regular negligence action, is important to note. Not just because, as we've noted, a fiduciary relationship can only be created by reposing trust in someone else, but because this is a title company we're talking about. And I think the implications of the argument are, I take the court's point. Well, you go back to the same title company. Is that smoke from where there could be fire? I think I take the court's point to be. And even if there was, I mean, people go back to titles companies just because they know a title company. I don't think that creates any inference or issue on the facts for the purposes of the statute of limitations argument. And the trial court didn't reach a lot of these other questions. The trial court only issued an order saying that it was dismissed for the statute of limitations. I tried, but that was the only finding. So I do think also that the two other arguments regarding the continuing tort doctrine and I guess the analogy I would call it to a legal malpractice suit are unavailing. I would say that for the continuing tort doctrine, I've already said it requires multiple harm. These are two discrete acts. I mean, even under the pleading of the complaint, the first act was in 2015, the second act was in 2017. And the complaint was filed over 4 years later. As far as the legal malpractice, all of the cases cited, I thought it was a unique argument, Your Honor, but all of the cases cited have to do with a relationship that arises from an attorney, and none of them, I haven't been able to find any that bring up this relationship to a title company. This court actually came out with a case, Askew v. Allstate Title, which is cited in the brief, and it finds that a relationship for a closing agent is between a buyer and a seller, or the parties to the transaction. And there's other case law that has suggested that when a lender is involved and there's mortgage documents that have to be signed and they're not recorded in time, that can also be something that a closing agent took under their wing, and there could be a breach of a fiduciary duty for that. There is no case law that I can find, so I can't advise the court of it, that creates a relationship to a prior seller. And so if you're a stranger to the transaction 2 or 3 years later, there's no case law that creates a fiduciary duty. I would also suggest, that this is part of the trial court's job when assessing a duty in this kind of an action. It's a question of law under McCain and countless other cases. It's not a question that goes to the jury. And this court, it dismissed the case multiple times and ultimately with prejudice based on this. I think that the ejectment is a non sequitur. It doesn't alter anything about when the cause of action accrued back in 2015. And we made the other tipsy coachman arguments in the brief, but that concludes my argument. I welcome any other questions that the court might have. All right. Thank you. Thank you.
May it please the court. Just as a point of procedure, we tried to get into Orange County at least a year before we filed in Hillsborough County. And for some reason, I'm not going to speculate, we were unable to do it. There was claims that it was just going to delay. I don't know why. Yes, over in Orange County.
In a year.
No. So anyway.
All we know is there's something.
There's something going on. Anyway, but you know what, Your Honor, I think you hit it on the head. Let's just put the fiduciary duty argument aside. Let's even put the continuing tort doctrine aside. It's simple. It's civil conspiracy. It's civil conspiracy. If I do one act in furtherance, and this title company was the only title company so unethical that despite their knowledge of the litigation and the claims, chose to go ahead, look the other way, and issue a warranty deed to move this along.
A conspiracy requires a common scheme and an act.
So let's go back to
The act is the closing in 2015.
No, the act is the ultimate theft of my client's property in both legal and equitable terms from them. That's the damage. Up until that actually happens, up until the time that because you have we all learned in law school, the power but not the right. And I think the equitable title holds to that. Just because I have legal title, I may have power, but the equitable principles don't give me the right. And my clients, these are immigrant from Haiti kids, and they have fought with their limited education, and they have fought to hold on. And it's that second transaction. And the reason, yeah, go.
For the civil conspiracy, your constructive trust, it would have to be someone who has an ownership right in the property now, which it does not include the title.
Oh, no. It's just a driver in a getaway car is part of conspiracy. They may not make $1. They just may be the idiots that drive up to the convenience store and allow somebody to go in and they drive off, never make a dime. If you in any way, shape, or form assist the grand scheme, which was the taking away of these people's property both legally and equitably, that's what this is about. So let's just let's ignore all of the issues with fiduciary duty. It's conspiracy. Roseanne Carter, the appellee, participated in a conspiracy knowing she should have never given away a warranty. She knew there was a claim. She lied to her title insurance company. She was willing to put all of her scruples and her morals on the line to assist this fraudster who had done multiple transactions with this title company. Lots of people get in bed with bad people because they make money. And that's what this title company is. They were a bad actor who were attempting to take these kids' property and to steal it from them. If this is a conspiracy, it is an ongoing conspiracy. 15 is tied to 17. It is as clear as day. And it was all to take away not only their legal title, but their equitable title as well. And that's what this is about. So even if we don't find there's a fiduciary, there's a conspiracy here. And the appellees are part of that conspiracy. And the thing about it is this. Statute of limitations are always motions for summary judgment. They're rarely done at the motion to dismiss phase. You know what? I've got proof to show what they did into June and beyond and spoliation of evidence. But that's an argument for a summary judgment. The fact that this case was dismissed with prejudice against this party based upon pleadings, when it has to be so clear from the pleadings that there's no possible way that the statute of limitations have been adhered to. I mean, it's got to be clear. If it's not, we move on to summary judgment. So, Your Honor, that's my final position. Is there any more questions?
Passion.
Yeah, I feel passionate about this.
I can tell that. Thank you both.
Thank you, Your Honor.
Interesting case. All right. Next up this morning, we have Family Creation versus Equity Union, City of Colorado.